Lordship, item number 4, we have filed our objection, but there's some error in number. We may be permitted to correct the same. Minor obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 5. Lordship, we would like to take an adjournment for the matter today.
5%.
Lordship, kindly let the matter be listed after 2 weeks.
5%. You are for appellant.
Yes, Your Lordship.
Your name
Dipti Rekha, I'm appearing on behalf of Mr. S.C. Das.
and you have informed the other sides. There are other councils
Lordship,
which are
actually,
appearing.
Lordship, I did not inform, but
Okay.
I'm here, Lordship, I'm looking for the response number 2. Lordship, I have not received a copy of the paper book till now, Lordship.
MS.
Lordship, actually, the appellant has taken back the file and handed over it to another council. But their name is not reflecting it, so we had to appear.
MS, your name?
Dipti Rekha Bangshiari.
D.
Dipti Rekha Bangshiari.
Bangshiari.
Yes.
Okay. D. Bangshiari. Learned counsel appearing for Mr. S.C. Das. Learned counsel for the appellant has sought an adjournment. Post of MS R. Barua.
Lordship,
B.
D. Barua.
MS B. Punya, learned senior counsel and additional public prosecutors. Assisted by MS
And Chakraborty.
M. Chakraborty, learned counsel for the respondent number 1, State of Assam, and MS P. Borua, learned counsel for the respondent number 2 are present. As the prayer is not objected. Therefore, adjournment is not objected by the learned counsel for the respondents. List appeal after 2 weeks. It is submitted by MS Borua, learned counsel for the respondent number 2, that a copy of the paperwork has not yet been received. First of office to furnish a copy of the paperwork to the learned counsel for the respondent number 2 within 2 weeks.
We have receipt of paper.
Detail.
Much okay.
So,
So this appeal has been preferred against the order dated 31/8/2023, which is at
Convicted
4 accused persons, my lord. I am for the accused appellant number 1, Nasiruddin Sheikh, in item number 2.
in the other one also. Applications were there.
Yes, madam.
Who are they? Next item to some.
For the other appearance, madam. In the other connected appeal.
You are pressing that application also.
Yes, madam.
I don't know. Babu. What we can. Ibrahim. So all of them were convicted.
Yes.
Yes.
At this stage, my lord, my humble submission is that, my lord, since this is a 2022 matter, my lord, paper book is ready otherwise, my lord. So, my lord, matter may be fixed for hearing, my lord, together, my lord.
Then we'll close this.
But if a date can be fixed, my lord, for hearing, my lord,
We can hear the I then.
today actually, my lord,
No
I'm
point
not prepared, my lord.
keeping it pending.
But today actually, I'm not prepared, my lord. So, my lord,
You're not prepared.
no.
Itu pura silver. And you?
Look, since matter but comes out of the same case, my lord, together, my lord.
Itu mean hello to my to. So I'm paper. For the purpose of consideration, PW3's evidence is enough. For IA. 389.
Actually, my lord,
There are eyewitnesses.
actually, there are two sets of witnesses, my lord. One set of witnesses are the relatives, direct relatives, son and wife and daughter.
But the relatives
And their
appreciated in any manner.
their presence is not corroborated or supported by the actual eyewitness, my lord, including the FIR name witness, my lord. Fazor Ali. He says that, my lord, he did not see the daughter and the wife at the place of occurrence, my lord. PW6.
Where is the FIR?
Page number 5.
Under. You missed one.
My lord, the allegation in the FIR is that when Josim Mondal was going to Alamganj Bazaar through a village road, all of a sudden the accused persons mentioned below intercepted him in front of the house of
He is
co-villager
not an eyewitness.
Fazar Mullah.
He is not an eyewitness. He is the informant only.
No, my lord, but the informant as well as my lord, Fakir Chan, they say that my lord Fazar Mullah, he was present at the place of occurrence. But this Fazar Mullah never said the that the wife and the daughter were present.
That is in front of the house of co-villager Fazar Mullah.
Yes, yes.
He did not say that it is a place of incident.
Yes, but if your lordship will kindly see the evidence of
He is not an eyewitness.
if your lordship will kindly see the evidence of PW2, Fakir Chan, he says that at page number 13, at about 6:30 a.m., one day while I was going through the road to board a bus in order to purchase goat in Noyarhat market, I saw Fazar Ali. So this Fazar Ali is this Fazar Mullah, my lord, working in this turmeric field near his house. Jamal Jogani and Nasir were sitting by his side. Jamal asked me as to where I was going and I replied to him. So invariably, my lord, he becomes a eyewitness, my lord. My lord, actually, this is the second round of litigation, my lord. Earlier, my lord, all the accused persons were acquitted by the learned trial court below.
Not for the death of Jasim.
Yes, my lord. Yes.
Not for
Because-
the death of Jasim. This case is for death of Jasim.
Yes. But in this case itself, my lord, the learned court below earlier acquitted all the accused persons, my lord.
Not for the death of Jasim, mister.
No, for this, my lord. If your lordship will kindly see the appeal memo, my lord, at page number 20. Thereafter, my lord, in the appeal, it was again remanded back. Page number 20.
On the same set of evidence.
Yes.
Who is respondent number PW3?
PW3 is the informant, man.
Hmm?
Informant. Yunus Mondal.
Or is the informant?
Yes. The lordship will kindly see page number 27, my lord, the earlier judgment of acquittal.
Page number 27 of which? Where?
Memo of appeal, my lord.
Memo of appeal.
Yes, last page. Last paragraph, my lord.
Memo of appeal. That has been set aside.
Yes,
There is
remanded
no
back.
value then.
Yes.
That has been set aside.
Yes,
We cannot harp on it.
yes, but
Why we should go to that?
Yes,
That is set aside.
yes, but there is an.
That finding are all set aside.
Yes,
It
but
is
there-
not in existence in eye of law. Why should we bother
No, no, just I want
into
to.
something
but
which
just-
is not in existence in the eye of law?
Yes, but at least there is an element of doubt, my lord.
No, that we cannot see.
Yes.
That has been set aside.
Yes,
And it is wiped out of existence.
yes,
Right?
yes,
So we cannot.
yes, but
We
my.
do not need
What-
to see that.
Yes, but our submissions will be in line with the reason of the learned foot below. In the earlier.
There are eyewitness
Applications.
accounts. You praise the appeal. I don't think this IA is to be considered on the basis of this as a prima facie. Prima facie, you don't have any case in the IA.
Lordship, we have filed our objection, Lordship.
We can set a early date for
Yes, madam.
hearing, but so far IA is concerned, since it has come up for consideration, we'll decide. IA. Confusion. And প্রথমে লিখক। Your S Das.
Yes, ma'am.
Yes, MS Das.
Lordship, the doctor had also corroborated the evidence.
Let us
of
see
the-
doctor's evidence. Injury report or the PME. Page. PME report, postmortem. Okay.
Page 126, Lordship.
126. What are the nature of injuries? Multiple penetrating wound present on the anterior abdominal wall on the upper half on left side,
Side.
4 oval shaped penetrating wounds present on the upper abdomen on the left side. 2 penetrating wounds present on the left side. Multiple penetrating injuries present. All injuries are full. And what are your grounds of objection?
Lordship, para 3, Lordship, of our objection. The informant was examined as PW number 3, and he, apart from stating the fact already narrated in the FIR, further stated that at the time of occurrence, he was having tea at home, and suddenly he heard hue and cry, and upon coming out, he saw the applicant, namely Nasiruddin, stabbing the deceased, and he saw and heard other co-convicts.
We have seen 4. Why 149? Why 149?
Well, initially there were 6 accused, 2 died during the trial. My lord.
Oh. Two died during the trial. Charge sheet was submitted against 6.
Charges were framed against 6.
6, okay. One 43. Hey, formally. AC to AC to. AC to AC to. All about it. Okay, Zamal. Who died? Abdul Sheikh.
My lord, Jamal Sheikh died and Abdul Sheikh died.
Zamal Sheikh died. And Abdul Sheikh.
Abdul Sheikh, my lord.
Hmm. Okay, লিখিব। Item 2, IA criminal 507/2022. Or Mr. S. Das, learned counsel for the applicant appellant. And MS N. Das, learned additional public prosecutor for the respondent number 1, state of Assam. Full stop. You are Mr.
Item 3, my lord, I will submit on behalf. I intend to submit for the other.
Okay. Tell your name.
S Nawaz, ma'am. S Nawaz.
Okay, ইটোত লিখিব কাৰণ কমনে হ'ব ওপৰ পাৰ্টটো। S. Nawaz, I 416/2020. S. Nawaz, learned counsel for the appellants, and Miss.
R Islam for restaurant number 2 informant.
Okay, in both the cases.
Both the cases.
Okay. তাহলে সেই ওপৰটো R. Islam, learned counsel for the respondent number 2, informant. দুটাকে হ'ব, খালি এটাত নৱাজ হ'ব, এটাত এজা, এটাত applicant হ'ব, এটাত appellants হ'ব। The instant interlocutory application. The instant application has been preferred by the applicant, equity applicants. Seeking suspension of under section 389 CRPC. Seeking suspension of sentence. Suspension of the sentence. The applicant has been undergoing. The applicants have been undergoing. Pursuant to the judgment and order of conviction and sentence. Judgment and order dated 31/5/2022. Date of order is same?
Same, my lord.
Dated 31/5/2022 of conviction and sentence. Whereby, post of, by the impugned judgment and order. SL in a connected criminal field, number so and so. The applicant, two applicants have been entirely undergoing sentence of life imprisonment pursuant to his, their conviction under section 302 IPC. Where by the impugned by the judgment and order impugned in a connected appeal, comma, a four accused persons, VIJ নাম কেটা দি দিব পেপার বুক 93 পর I've been found guilty of the offense under section 302. Okay, have been convicted and have been convicted for the offenses under sections 148, 149, as well as for the offense under section 302/149 of the Indian Penal Code. Full stop. For the offense under section 148, 148/149 IPC. The applicant has been sentenced to undergo rigorous imprisonment for a term of 3 years with fine of rupees 2,000 each with default stipulation. The investigation was initiated on the basis of a first information report lodged by one Sarkar Yunus Mandal, PW3. So as part of FIR, the informant's nephew, Zasim Mandal, was attacked on a village road at about 6:30 AM on 1998. So at that time, Zasim Mandal was going towards Alamganj Bazaar, and all on a sudden, the accused persons named in the FIR, 6 in number, including the appellant, intercepted him in front of a co-villager. It was alleged in the affair that the accused persons injured Zasim Mandal grievously by stabbing him in his abdomen with dagger. As a result, Zasim Mandal died on the spot. Mr. Das, learned counsel for the appellant, has submitted that earlier the learned trial court had acquitted all the accused persons, including the appellant. But on an appeal, in an appeal preferred against acquittal, the judgment of the earlier judgment of the learned trial court was reversed.
Yes.
Was set aside. And thereafter, impugned judgment and order dated 31/5/2022 has been rendered. It is a submission that on the same set of evidence, the appellant was acquitted earlier, but on the second occasion, the learned trial court had found all the accused persons guilty of the offenses mentioned earlier. There is a submission that there are inconsistencies in the evidence of the prosecution witnesses. What is your submission? Which PW?
My lord, my submission is that, my lord, PW4 and PW5.
PW4.
PW4 and PW5, my lord, who happens to be the relatives, the wife and the daughter of the victim, my lord.
It is a submission that PW4 and PW5 were relatives of the deceased, and as such, their depositions cannot be accepted without proper screening.
But similar cases with regard to the other PWs as well, my lord. None of the PWs, my lord, 7 except PW6.
Mr. Das, we are not hearing you.
My lord,
learned traditional public prosecutor, has, under and referred to the post-mortem examination report, which has indicated post-mortem. Hmm. Which has reported that the deceased sustained multiple penetrating wounds on the abdominal part and the injuries reported in the PME report are consistent with the deposition of the informant who was examined as PW3. Also, we have gone to the materials on recording, including the evidence of the witnesses and the PME report for the purpose of consideration of the prayer for suspension of sentence. First of, it is found that the informant, that's PW3, it is found prima facie. It is found prima facie that the informant, that's PW3, in his evidence had indicated about the presence of all the applicants, all the accused persons, all the four accused persons who faced the trial. From the deposition of the witnesses, it has further emerged that the accused persons were not unknown to the witnesses as they belong to the same village. Full stop. Having regard to the nature of acquisition made against the accused persons, the manner of commission of crime and the gravity of the offense and the desirability of releasing the accused persons, convicted accused persons on bail, this court is of the privacy view that this is not a fit case for exercising the power under Section 389 CRPC for suspension of sentence. Full stop. In such view of the matter, the instant application stands rejected.
But in the main appeal matter, the date may be fixed, man.
Yes, what is your submission?
Unlike it.
Itu paper on dia. Itu goal. Itu Nasiruddin. Fakir Chand Ibrahim
And Babu Hazrat, my lord.
Babu.
My lord, unlike the case of my learned friend, my lord, my case is diametrically opposite, my lord. My lord,
Diametrically opposite.
yes, my lord. My lord, our presence at the place of occurrence itself, my lord, has not been established even prima facie, my lord. My lord, there are two sets of witnesses, two independent eyewitnesses, PW2 and PW6, and three other witnesses who are related to the family of the deceased. Now, my lord, PW2, my lord, will kindly take up PW2. PW2, my lord, page 13. My lord, PW2, my lord, mentions that Jamal Jogani, his deceased, my lord, and Nasir, my lord. Nasir is who my learned friend was representing, my lord. They were the ones who attacked and assailed the deceased, my lord. PW2 does not even place us at the place of occurrence, my lord. PW2 is an independent witness, my lord.
Jamal Jogani was not the disease.
Jamal Jogani, my lord, they were the same person who died, my lord.
Hmm?
Jamal Sheikh, my lord, one person had died, my lord. That is the same person, my lord.
That is Jasim Mandal.
Jasim Mandal is a deceased, my lord.
Uh,
My lord, Jamal Jogani is one of the accused persons, my lord, who had died during the pendency of the trial, my lord.
yes.
So, my lord, Jamal Jogani and Nasir were the assailants, my lord. As per PW2, who happens to be an independent eyewitness.
Going to the road to board a bus near the is good. I saw. Other Zaman during your destiny. Someone can see it. Actually, to inform each question. One, two, three.
My lord will also see, my lord, the evidence of PW6.
Absolutely. Ibrahim. Babu Ibrahim. Babu is alerted. Okay. Okay, PW.
PW6, my lord, page 26.
Hmm. Hmm. Hmm.
Who is respondent number 5? Oh, sorry, PW 5.
PW5, my lord, is the daughter of the deceased, my lord.
PW 6 admitted the presence of this wife of the deceased on the spot.
Yes, my lord. My lord,
PW 6 and the daughter was there also.
my lord.
And two sets of evidence, weighing the two sets of evidence as per your submission and coupled with the PME report, the nature of injuries, it cannot be said that he has suffered multiple injuries. PW 4 and 5.
But there are
Worship PW 2, 3,
Weighing
4,
the
5, and
evidence at
6
this
and 4,
stage,
four-
Mr.
one humble
Nawaz,
submission,
I
my
don't
lord.
think it is.
My lord, one humble submission, my lord. Two sets of evidence, PW2 and PW6 are exonerating me. Three other witnesses, PW3, PW4 and PW5 have implicated us, my lord. Now, my lord, the evidence of PW3, 4 and 5 itself is contradictory, my lord, on the face of it, my lord. My lord, if my lord permits, I can
We
show.
are not going for meticulous examination of the evidences.
My lord,
To
yes,
at this stage, we are on the matter whether it is a case at this stage for suspension of
yes,
sentence.
my lord. My lord, but
The
prima
gravity
facie-
of the offense,
yes, my lord.
the two sets of witnesses, as you are saying, but the other set of witnesses are also admitting the presence of this PW 3, 4, and 5 at the spot.
No, my lord, there is
Present at
some
this spot,
dispute
sir.
on that, my lord. My lord, will you kindly bear with me, my lord. My lord, PW3 is the informant. He is the uncle of the deceased, my lord. And
That
he admits,
whether they are interested witness
No, my lord, I'm not on the plea of interested witnesses.
looking
my lord.
for conviction of the accused persons, we are not going into that aspect right now.
My lord, I'm not taking that plea, my lord, because related witnesses are also, my lord, competent witnesses. My lord, I'm not taking that plea. My plea is that PW3 says he witnessed the incident clearly. PW4 is the wife. My lord will kindly see the cross-examination of PW4, my lord. First line of the cross-examination of PW4, my lord. Page 22, my lord. I wailed and shouted. Later, people arrived there. Yunus Mondal, my lord, PW3, came there, hearing the alarm raised by me. He came there in a run. I told him that the accused person is making the assault. Yunus asked the other persons about the incident. So, my lord, as per PW4, my lord, PW3 is a post-occurrence witness, my lord. He arrives there, he asks the people about what had transpired, my lord. And yet he comes and deposes as if he had personally witnessed the incident.
Who?
PW3, my lord. The informant, my lord. He deposes as if he had personally witnessed the appellants attacking the deceased, my lord. And yet PW4, the wife, who also claims to be an eyewitness, she deposes that after hearing her wail and cry, he arrives at the scene. She tells her what had happened. Likewise, my lord, if my lord, the entire evidence is seen, my lord, PW3 does not mention the presence of PW4 and 5. PW4, the mother does not mention the presence of PW5. PW5 does not mention the presence of my lord PW3 and PW4, my lord.
Your witness, PW6,
Yes, my lord.
from whom you are drawing,
Yes, my lord.
trying to draw support.
Yes, my lord. My lord, even in his cross-examination, my lord will kindly see. Page 28, my lord.
Where is PW6?
PW6, my lord. Page 26, my lord.
26.
Fazor Ali.
Fazor Ali, my lord.
See, page 27.
Page 27, my lord.
Zesim's daughter Jeleka,
Yes, my lord.
wife Sakura,
Yes, my lord.
son Sabur
Yes, my lord.
came out of the
Out of
house.
my lord. But this is
And
after,
this is
my
not
lord.
a one incident, it is a multiple.
Yes, my lord.
Multiple
Multiple.
penetrating wound.
Yes, my lord.
It cannot be within 1 minute.
Yes, my lord. And again, my lord, PW7, my lord, PW7 cross-examination first line, my lord. These are witnesses with whom the prosecution has gone, not declared them hostile, my lord. PW7, my lord, page 31 cross-examination first line.
Oh, this Mr. Nawaz, it is not an exceptional case to make out a case for suspension of sentence. Hard. Application, no? I got it. Mr. Nawaz, learned counsel for the appellants, has drawn attention to the evidence of PW6 and PW7, to contend that.
PW2, 6 and 7, my lord.
2, 6, and 7 to contend that the presence of the other witnesses like PW3, PW4, and PW5 at the place of incident was doubtful. So according to him, PW3 was called by PW4 after the incident had occurred. And as such, PW3, who is also the informant, was a post-death incident witness. On the other hand, Ms. Das, learned additional public prosecutor, a PME report to PME report to that. MS Das has also contended that from the evidence of the PW2 to PW7, it does not go to, from a combined reading of the evidence, depositions of the PW2 to PW7, it do not go to indicate that the PW 2 to PW5, PW3, PW4, and PW5 were not present at the place of incident at the relevant time. Full stop. MS Das has further contended that the deposition of PW3 is not inconsistent with the version given in the FIR. Full stop. আগৰখিনি লিখি দিম। Just simple. Penetrating against the PME report, penetrating wounds, factors. Same. When you want hearing,
My lord, any,
till
my lord, April, April, my lord.
Mr. Das, where is Mr. Das?
He had to go for another hearing. He had another hearing in court
Okay.
number 17, my lord.
লিখক, দুইটাতে লিখক। এইটা separate order, এইকেইটা separate order, বাকিটোতো combine কৰি দিওঁ। Criminal appeal দুটা। Third, Mr. S. Das, learned counsel for the appellant in criminal appeal number so-and-so, and Mr. S. Nawaz, learned counsel for the appellants in criminal appeal number so-and-so. Also heard Ms. N. Das, learned additional public prosecutor for the respondent number 1, state of Assam, and Mr.
R Islam.
R. Islam, learned counsel for the respondent number 2, that's informant in both the appeals. So as the paper book is ready and the learned counsel for all the sites are served with the paper books, comma, the counsel for the parties have submitted that the appeals can be posted for hearing. First of list both the appeals together on a in the month of April.
My lord, date if, my lord.
After
I-
due vacation.
In the month of April, I am on a date to be fixed by the office. I don't go on fixing normally.
Obliged.
Deeply obliged, my lord.
May I please, Your Honor?
Yes, madam.
Your Honor, kindly go through the previous order, Your Honor.
Yes, madam.
Kindly go
Lordship,
to the,
in the morning, I made
Yes, yes.
correction. My junior couldn't find the objection, Lordship, I take liberty to file afresh.
Okay. Heard
N. Hassan.
and Hassan. Learned counsel for the appellant and MS B. Bhuya, learned senior counsel and additional public prosecutor assisted by MS
I'm
Chakraborty.
Chakraborty.
M. Chakraborty, learned counsel for the respondent number 1, state of Assam. Full stop. MS Bhuya has submitted that an objection to the interlocutory application will be filed within
Today,
a week.
Lordship,
Full stop.
Obliged.
fresh objection.
A fresh objection to the application filed for suspension of sentence will be filed within a week. Full stop. List the case accordingly after a week.
Lordship.
List the appeal. List the application.
Item number 6.
Pass to 9, go pass to 8. Don't hold. Appeal is now. Yes, Mr.
My lordship, appeal against conviction, my lord, under section 302.
Appeal against conviction.
Today is for consideration of the IA, my lord, for stay of the judgment.
LCR received.
LCR received.
Let's see.
Yes, Lordship.
Let's see, sir.
Sorry.
Paper book is not.
Paper book noted.
Paper book is not there.
It's not there, Lordship.
The allegation, deceased, my lord, deceased is the mother-in-law of
Is
the.
the FIR any part of the appeal memo or
No, my
no?
It's not there.
Disease is
the mother-in-law of the accused.
mother-in-law of the
Accused.
appellant.
Appellant, my lord.
Yes.
Who lodged the FIR?
FIR was lodged by the father-in-law of the appellant, my lord. The husband of the deceased.
Husband of the deceased. তারিখ ছয় মান বলে দুটোর ভাবে কম নাকি লড়ার হবে মোর পুত্র At that time, at the time of lodging the FIR, the victim was not dead.
No, she
Yes,
expired
Lordship.
in the
After
hospital
2 days,
next
she
day.
expired.
Next day.
Next
After
day.
2 days, Lordship. Date of
What is the
occurrence?
nature of injury?
My lord, the
Head injury, Lordship.
Head injury.
Yes. Multiple head injury.
my lord will come to page 23, my lord. 22, my lord. That is the evidence of the PW to the doctor, my lord.
Doctor, 1 minute. W2.
Lordship.
Right temporoparietal region.
Yes.
Then left parietal region.
Yes.
My lord, that is contusion.
Comminuted fracture of right temporoparietal bone are detected. Subdural and subanechoid hemorrhage
Hemorrhage
are
were-
present over both cerebral hemisphere. That was due to trauma as a result of head injuries sustained as described. All the injuries were postmortem and caused by
Blunt force impact.
Now, my lord will come to
8
the
to 16, 8 to 16 hours.
Yes.
Okay.
the cross part may also be seen.
Doctor,
Doctor. In the cross part, it is said, my lord, the injuries, my lord, may be sustained by falling on hard substance. That is an opinion of the
Okay.
medical expert.
PW three
Yes.
Yes.
damaging
Damaging, my lord.
for the time being for the consideration of this.
Yes.
No, I'll
I-
take lordships to page 25, the cross-examination part of the PW. And the IO, that has been, it is contradictory, my lord.
He is a boy of what,
7 years.
9 years
9
at the
years.
time of deposing. At the time of incident, 7.
Yes.
You cannot expect him to be
Tutored best.
that much having memory like
Yes,
Intel Pentium.
At the time of giving a statement to the police, that was not stated before the police. Those contradictions have been brought on record, my lord.
Right, but
Contradictions are,
let us have the any 164 statement.
once of the
That boy,
PW3 is, it should be in the records. my lord.
huh?
Perhaps in the record, Lordship, it is not annexed here.
I have the 164 statement. Well, I have the 164 statement.
I'm looking from the original one.
My lord.
Reflection time. Reflection time.
Mm. The IO has said, my lord, it was not stated before the, and
You
that,
don't expect a child of 7 years. But he has said about before the magistrate.
Yes. Lord.
That is whether let us see his cross-examination or cross-examination.
it
Did you
was,
put
it
that
was,
164 statement?
my lord,
What is?
regarding 161, my lord,
He's examined as a witness,
Yes,
number
3,
PW3. Lord.
PW3.
Page 24 of the appeal memo.
Did you put
Yes, suggestion was put to him, he denied, my lord.
who?
The PW3.
About exhibit 3 in your cross-examination? About exhibit 3,
No, my lord. About it was
Huh?
be-
You were silent.
regarding 161.
but 164 is also there.
Well, contradiction is there in 161 and the.
But 164, he has exhibited.
Yes, that is there.
Did you not put him?
164.
Yes, about his 164 statement. He is silent.
161 was put to him and that has been
But
stated.
that is
That is
also,
not exhibited.
that is on a better pedestal,
Yes.
on a higher pedestal. It was before a magistrate without the presence of police. And he has exhibited
That
his
is-
statement. And that is,
But
I think, on a
161
better pedestal.
better pedestal, my lord, but 161 can also be used for contradictions, my lord.
Right,
We are
but
not-
if when
it's about consistency.
164 statement is there and he had exhibited, had he not exhibited it?
I can understand, my lord.
Because see the cross-examination, we are not on the
I can understand.
final appreciation of evidence.
Right.
But prima facie, it appears that
Once,
you have not put that
164
164 statement into challenge, neither anything was done.
161 was put to him.
Only 161.
He denied, my lord, and the IO says, my lord, IO at page 32 of my,
Now,
of the IA, my
One-
lord, if I may take
one,
your
one
lordship.
one minute.
I-
You have not,
Cross
you were
part of the
silent
IO.
on 164.
But contradiction can be proved by this way, my lord, as per VK,
It is one, there are
Yes, sir.
statements.
my lord,
There are two statements.
is. Once.
One is before the magistrate also,
Yes.
without the presence of
Police.
police. And that statement corroborates the statement made before the court.
Mhm.
And you have not made any whisper about it in the cross examination.
But the contradiction is there apparently from in the 160.
Is it not your duty to put the 164 statement also to challenge?
Prove the contradiction, my lord, in VK Mishra, my lord, it has been
One
stated
minute.
how contradiction is required to be proved.
Mhm. Yeah. Oh, yes, what have. Hmm. How many witnesses?
10
Ten
witnesses.
witnesses.
And most importantly, my lord, the husband of the accused, my lord, was not examined. He was the person who saw the deceased lying on the.
He is in a position,
we are
devil and
not-
the deep sea. He is in a position, devil and the deep sea.
I'm
On
not.
one side, devil, the other side, deep sea.
Yes, yes.
One, on the one side, mother, one side, wife.
I can understand.
He is in a position who should not be in a position.
Regarding the contradiction, my lord, the contradiction is proved as per the VK Mishra, my lord. What VK Mishra says, my lord, that has been done, my lord, to prove the contradiction. And now as the contradiction
That
is,
is the only one.
my lord,
Should not that 164 statement should also be demolished? That says about only 161 statement. What
Right.
about 164 statement? It has no value in the IR law.
it does have, my lord.
What kind of value? It is higher in pedestal than 161 or in lower? Hmm? More. Good for your me.
PW10 is the IO, my lord. In his cross examination.
PW10.
PW10 is the IO. Nothing with regard, my lord, that he heard sound and he saw from the gap of the door that those were not before the police. And with regard to that, suggestion was put to the PW3 also.
Fact that you did a vanishing act thereafter, immediately after the incident.
My lord, that,
What is your explanation?
well,
What is your explanation you have put forward?
yes. Well,
You were there.
that was.
Your son was there.
it-
Neither your father-in-law
No,
nor
no,
your husband
Only 3%,
were there.
3%.
Your mother-in-law, you and your son were there.
Yes,
And things were found out immediately thereafter. But you did a vanishing act
yes. That,
with your son. Right? So far, that is also not put to challenge. That part is not demolished. That shut your mouth. Shut your mouth. Don't say anything. Those are not there. Yes, this may be not in the 161 statement, but other evidence in the totality and the nature of
only
injury
that part,
sustained.
the vanishing
not
act, vanishing act.
Disbelievable that you went there to your mother's place, to your parental house,
Parental house.
and you were there.
Hmm.
And there was nobody in the house. That is also a fact, perhaps.
That-
Looks like. Then your absence from the very next
that-
moment, along with your
Yes.
son, that
PW1 evidence, my lord, that part that she vanished comes from the information from the husband of the accused. But
Understand.
husband is not deposed.
PW3. PW3 has said in clear terms. That's whether that was put to challenge. And in totality, don't find at this stage.
No, my lord, for the contradiction, but may I,
No, the other
Yes,
circumstance,
the-
only one, as Jasmine Bachitra Singh right from. Those are there,
yes,
but the other.
the
you have to
vanishing
see
part, my lord.
only one part of 161 statement that he did not depose in that aspect, but the totality of circumstances indicate prima facie nothing to nothing else but to you. Because you have to,
That-
your defense plea is what?
The other
Let us see
witness,
31, sorry, 313. 313.
Total denial, Lordship.
No explanation.
No explanation.
Abscondence could be one factor at this stage.
my lord, now, how the death has been caused, my lord, on the other hand,
Broken hemorrhage.
yes, that the medical expert has said, my lord, that could be also because of the fact of falling down on the hard substance.
Because to that regard,
So
Lordship,
that-
after having 6 injuries, that is on the head injuries, so it is become quite impossible to
And
believe
the-
that
and
he has-
and this,
That
death is
nature of
caused-
injuries,
that
Yes.
has been alleged.
nature of injuries in a kitchen.
The weapon is not there. Weapon is not recovered. The alleged lathi. Alleged stick that has been not,
Have you put that
my lord.
to the child? Have you put that to the child?
He had denied
Who?
the child. PW3, my lord.
Denied. Now let us see your IO. Your IO,
Nothing was seized in this case.
Lathi was here.
No. Well, on the one part, there is the contradiction, the weapon is not recovered, my lord.
Show me any other hypothesis that it is not, that other hypothesis is possible on prima facie. Show me that any other hypothesis is also possible.
Yes, the pushing,
It is not-
the appellant pushed the deceased. That suggestion was put.
But the nature of injuries, the PM report indicates that is not consistent with pushing. Prima facie.
The opinion, the expert gives the opinion that that is also there, but I'm not saying something off record, my lord.
Yeah, Munir. Yeah, fine. You cannot give it. পেপাৰ বুক হৈছে নাই, পেপাৰ বুক হোৱা নাই ন? পেপাৰ বুক Okay, Mr. Morin, let the paper book be ready then. Heard, Mr. Considering that the matter pertains to a lady, let us PK Munish, learned counsel for the applicant appellant, and MS H.S. Bora, learned traditional public prosecutor for the respondent number 1 state also. Full stop. Oh, and Mr. Anjay Gogoi. Yes, what is your submission? You are for, you informant means? You are husband or what?
Father-in-law.
Father-in-law. Yes, what is your submission?
So PWT already stated that the,
Opposing the prayer.
yes, I oppose that.
And Jay Gogoi learned counsel for Raspanava, 2 informant, full stop. Office to prepare the paper book and list the instant interlocutory application for suspension of sentence immediately after completion of the paper book.
A month may be fixed, my lord, if possible. After due vacation, my lord,
Maybe after 4 weeks.
deeply obliged.
May it please your lordship.
Password, kindly password and for the timing.
No password, madam. You're for whom?
Miss V. Bhuya.
You are on
Yeah.
IA.
Yes, lordship, here we have filed a IA for suspension of the sentence, lordship, and they have filed an objection, lordship, to it, lordship. The
302.
302, lordship, he was convicted for imprisonment for life, lordship, under section 302, lordship.
You are representing whom?
Miss B. Bhuya.
Huh?
Miss B. Bhuya.
Okay, PP. I thought that you are informant.
Although, lordship,
Okay.
record,
Timing then.
lordship,
Huh?
but
Is he received or not received?
received, lordship, but paper book has not been, paper book has not been ready yet. After
Can make a fold after some time. Seven to. Oh,
We file our objection. my lord.
This is a appeal from jail lordship, and we have filed this IA for suspension of sentence lordship. The petitioner was convicted under section 302 for imprisonment for life lordship.
hmm.
Well, here in this case, lordship, the main ground which I have taken the for suspension of sentence lordship, the prosecution has examined as many as 12 witnesses in support of their case. Out of 12 witness lordship, there are 2 witnesses they claim to be eyewitness, PW 5 and PW 6. And another is and also the learned trial could put most emphasis on the evidence adduced by the PW 5, that is the eyewitness PW 6, and PW 11, that is the IO who recorded the dying declaration of the deceased lordship.
IO 9 declaration.
Yes, IO is PW 11 lordship.
Hmm.
But as per medical report, the main cause of death of the deceased lordship, that is due to
Septicemia.
septicemia lordship.
Septicemia.
Yes, and the deceased died lordship. The IO recorded the statement lordship immediately following the day of the incident lordship, after the day of incident, next day of the incident lordship. And she died lordship after 10 days lordship.
Lordship, might have a good case in appeal, but in at the face of it, it doesn't have any good case in this one, my lord, in interlocutory application. Because lordship, there are judgments of Honorable Supreme Court I could not bring it today. If the victim dies after 10 days, that lordship, he may not be convicted under 302. Lordship, last year judgment, but today I could not bring it, my lord. But your lordship, he might have a good case in appeal, but for consideration of I don't think he has a good case because there are oral dying declaration before 3, 5, 6, 7, and 11 also, the IO, my lord. And there are eyewitnesses to the occurrence, my lord. And this one accused person is the husband of the victim.
Husband of the victim.
Husband, he poured kerosene. And at the time of occurrence, there are other persons who have seen the witnessed the occurrence, my lord.
LC has come.
Elsie is there, my lord.
Let us see the FIR.
Lordship.
Who was the FIR?
Is the father of the deceased lordship, PW 8.
When the lady died,
She died lordship 4/11/2022. I have
4/11.
found out somewhere in the record lordship, in the inquest report lordship,
After
11.
4/11/2022. That was date, time of death.
11.
reason to
Inquest report.
the medical report postmortem.
Postmortem is up to.
Hmm. She was admitted with 60% burn injuries, my lord.
Here is the affair in the allegation that the accused lordship poured petrol upon the lordship body of the deceased and set fire on her lordship. Here, during the there is nothing on record which goes to show that lordship it was the petrol by which the deceased was burned by the accused lordship. And nothing was seized lordship. Neither the petrol bottle or that is nothing was determined during the trial whether it was a petrol or kerosene or any other inflammatory substance lordship.
She was treated where?
She was treated lordship first the Bokaghat Civil Hospital, thereafter Jorhat Medical College, as per the version of the PW's lordship.
Is there any doctor?
Doctor lordship
been
PW, it is the medical PW1 is a medical health officer.
Anyone from Bokaghat Civil Hospital?
No lordship.
Hmm?
SKK Civil Hospital. Yes. PW1 is a subdivisional medical health officer, SKK Civil Hospital.
Hmm?
PW1 is a subdivisional medical and health officer,
PW
S1.
one. Is the autopsy doctor or he treated also?
Autopsy doctor, man.
Only autopsy
Yes.
doctor.
Autopsy doctor.
And where is the IO?
I was PW11 lordship.
Hmm. Agree with it. No.
Initially, Lordship, the case was
Admissibility of exhibit 5
exhibit 5.
cannot be gone into at this stage.
My lord.
But it,
Apparently, it is not admissible, Lordship. Because Lordship, the
at this stage, this exhibit 5
Ah.
tilts the balance against you. Clear implication.
implication, Lordship, but whether it can
Whether he
be,
has followed the proper procedure or not,
whether it can be treated as
But-
dying declaration, Lordship, because that statement was recorded, Lordship, prior to 10 days prior to her death, Lordship.
hmm,
That statement was recorded 10 days prior to her death, Lordship.
so that was very
It
near to the incident.
was
Meaning
not,
thereby, it is near to the incident than to the date.
Lordship, kindly appreciate one thing.
But this exhibit 5,
Lordship, appreciate one thing, Lordship, the main principle behind admissibility of a dying declaration is that the person who is dying may not tell a lie, Lordship. And as
so
he or
at
she
this
is
stage, that
counting her last hour.
presumption is that the lady was telling the truth.
No.
Unless on a full-scale hearing,
Had it been
That-
taken
Plus-
immediately prior to her death, that would be.
Vis-a-vis the
would have been
evidence
different.
of PW
PW
3,
5
5,
and
6,
PW
and
6.
7.
PW
Yes.
6. And it is a fact that she died of burn injuries. Petrol or kerosene, that is immaterial.
But whether the
But
injuries,
PW 5 and PW 6, yes.
whether the injuries sustained by the victim is sufficient to
But
cause.
apparently there is no doctor was examined from Surat's Golaghat Civil Hospital, otherwise
Treating doctor,
treating doctor. Just because autopsy
Right.
is done,
Lordship.
that was up to 15 days.
Right.
But at this stage, PW 5 and 6 and along with exhibit 5, he has said, IO has said that whether I followed the proper procedure or not, he is in doubt. But still it is there. It has been exhibited. Exhibit 5 has
Admissibility,
been exhibited.
whether it can be, it is a dying declaration.
No, we are, as regards the
Whether
suspension
your
of sentence,
IO has been confronted, I don't have the.
confronted. I read it. Maybe you have a good case at the time of hearing, or maybe it is not a. It might be a case of culpable homicide not amounting to murder, but at this stage, it might turn out to be a better proposition for you after spending some time. Heard Mr.
B Haldar.
B. Haldar, learned legal aid counsel.
Legal aid counsel.
Legal aid counsel. For the appellant, MS P. Bhuiyan and MS P. Bhuiyan, senior counsel and additional public prosecutor assisted by MS M. Chakraborty.
Yes.
Learned counsel for the respondent number 1, state of Assam. The instant application is preferred by the appellant seeking suspension of sentence under section 389 of the Code of Criminal Procedure 1973. First of all, the applicant as the appellant has preferred the connected criminal appeal criminal appeal number criminal appeal J stroke 130 number 132 stroke 2022 first of by the judgment against the judgment and order dated 11/8/2023 first of passed by the Learned Sessions Judge Golaghat in Sessions case number 6 stroke 2023 first of by the judgment and order dated 11/8/2023 the appellant has been convicted under section 302 Indian Penal Code and appellant has been sentenced to undergo a rigorous imprisonment for life and to pay a fine of rupees 10,000, in default of payment of fine, to undergo simple imprisonment for 3 months. Mr. Haldar, learned counsel for the learned legal aid counsel, has submitted that the prosecution witnesses, PW5 and PW6, who had purportedly given eyewitness accounts, did not state before the police during the course of investigation that the appellant threw petrol on the person of the victim. Full stop. He has further submitted that as per the postmortem examination report, the victim who died on
4/11/2022.
4
11/2022.
4/11.
4/11.
After the incident of 26/10/2022, the victim died due to septicemia as a result of ante-mortem burn injury. All over the body surface. And as such, as such, comma, the there cannot be as such, comma, the charge under section 302 IPC is not sustainable in law. Full stop. Objecting to the prayer for suspension of sentence, MS Bhuiyan has strenuously urged that as per the eyewitness accounts of PW5 and PW6, comma, the victim who was incidentally the wife of the appellant, which marriage solemnized as about 3 months earlier, comma, they had unerringly pointed to the appellant as a person who had thrown inflammable materials like petrol. Full stop. MS Bhuiyan has further pointed out to exhibit 5, P5, which is a statement recorded, which is a statement of the victim recorded by the IO on 26/10/2022 to oppose the prayer for suspension of sentence. Full stop. Then we have considered the positions of the witnesses as well as the documentary evidence led by the prosecution in the trial. Full stop. Para. Exhibit P5 is a statement of the victim recorded under section 161 CRPC by the IO within bracket PW 11. Full stop. As per the evidence of PW 11, comma, the said statement was recorded at when the victim was being treated at the Golaghat Civil Hospital, and the statement was recorded immediately after the incident. Full stop. As per exhibit P5, comma, the victim had implicated the appellant. Full stop. Considering the fact that such version of the victim was also prima facie corroborated by the purported eyewitness accounts of the PW5 and PW6, comma, this court is of the view that the present application seeking suspension of sentence is not merited at this stage. In view of the nature of accusations against the appellant and the gravity of the offense. Consequently, comma, the present application stands rejected. At this stage, I have mentioned
The observation made in this will not have.
Otherwise, it is not. It is not otherwise it is interlocutory application. At this stage, I have said. I
Lordship,
have
main
said
case-
prima facie.
Lordship, in the main case, since the LCA has been received, I think it's received. Paper book. we prepared.
Paper book. Main case only.
Lordship.
P. Haldar, Learned Legal Aid Counsel for the appellant. MS B. Bhuiya, Learned Senior Counsel, and a learned additional public prosecutor. Assam, assisted by MS M. Chakraborty, Learned Counsel. For the as the trial court records have been received, comma, the office shall prepare the paper book, comma, as observed, as expeditiously as possible, comma, as observed in the order dated 23/4/2024. Release the case after 4 weeks. Release the appeal after 4 weeks.
23,
It is observed already.
or no, maybe date minus 23/4/2024.
23/2.
For hearing item number 12.
I don't know.
If your lordship,
Yes, yes.
I'd like to place two decisions, my lord. Since there was no eyewitness,
Sarah, okay. And what about your,
the second
what about your
difference. between-
defense witness?
I-
DW.
They
Have you
said,
seen his DW
DW,
evidence?
they said they
His
didn't,
friends,
my lord.
they know, but they
his
didn't say
friends
that
did
That-
not support him.
Then,
So what is your submission? But
uh,
just because falsity in the defense witness, suppose,
I know.
falsity, let us say falsity
Lordship.
or weakness
my lord,
regarding the plea of
alibi,
alibi,
my lord.
that will not strengthen the prosecution case,
No, that is true.
right?
Yes,
Now, on the basis of the evidence laid by the prosecution, what do you say about because from the surviving victim, say,
PW
or
six,
informant,
PW six. Whether she is a reliable witness or not.
because that allegation about 376, she
That the accused
Made.
persons have committed.
made,
Yes,
that was belied by the medical evidence against her,
yes,
against the disease also,
that is not there.
that was not there.
Lordship, but
So that accused persons were acquitted of the charge under section 376. Now, from what, because you were not there, we are discussing, from the evidence of informant, things move like this. Then there was a separation point. And the separation point, after separation or at the separation point, the evidence of PW3 is somewhat while connecting the persons with the 2X. After separation, she said that two incidents had happened.
yes,
One with her, one with her elder sister.
sister,
And she connected the persons with the two incidents. And somewhat there is some inconsistency. That is what the submission of Mr. Prasad.
my lord.
So how do you reconcile that apparent inconsistency about the persons connected with the two separate incidents? Have Am I
Yes, your lordship is clear.
clear
Yeah,
to?
yes, my lord. Let us see the evidence of, first, I want to take you to lordship to the evidence of, lordship as a hard part, as a hard. At page
Yes.
3, FIR, my lord,
FI.
page 3. Humble submission is that around 12 a.m. last night, 5 boys of Zangal, Varikau, came to the house of Sri Mongol Hasda of the same village, and they gagged the mouth of my elder sister Renuka Hasda and me, and took both of us to Golandi River. Your lordship will kindly note this part, Golandi River. Therein, the dead body was found, bloodstains were found, and it was exhumed from that place only, near that place. The details of the occurrence are that my elder sister Shri Renuka Hasda had a love affair with Niran Doimari from Kanpur, and he visited us frequently.
Original record to- Original. record. Yes.
Lordship. So, Lordship, motive, although it's not an integral part in a case where in a eyewitness's account is there, my lord, but your Lordship may discern from the FIR, allegation made in the FIR, the motive for killing, my lord. The details of the occurrence are that my elder sister Renuka Hasda had a love affair with Niran Doimari from Kanpur, and he visited us frequently. Although some boys from our village prevented him from visiting us, the boy
Marks.
may not be, my lord. In every case of
That has
376,
attained finality. Acquittal of the accused persons. Anyway,
my lord.
according to PW 6, this man was not involved with the act, with her.
But now, question of 302, whether
Now,
they are
yes, this
involved,
man
my lord.
was not involved with her,
Yes, my
right?
lord, my lord. May
But
not be,
that has become, made the his informants weight somewhat diluted,
my lord. That is true. That is true.
making an
My
allegation
lord.
of such a serious nature. And
Lordship will kindly appreciate these, the persons from these village areas.
right, but this much, it is not highly
Commission of bad act doesn't
highly
mean, my lord.
sophisticated thing. It is not a highly sophisticated.
No, my lord. The commission of bad act doesn't
It's a
mean like,
simple thing.
my lord.
No. We are saying about
And she is
a
the major, my
refined,
lord.
in a refined manner, but I have seen the
My-
being a refined
My
statement.
lord.
That does not mean that it is not there, it
My
is
lord.
there. And that much a major lady.
My lord, major lady, 18,
Major lady.
19 years.
Had it been a child, it could have been a different thing.
My lord.
That is,
lord.
she is
Even in
major.
case of child also, we have found Jasmine's, my lord, sometimes injury because
But she is major.
she is major.
Yes.
My lord.
Proceed.
PW6,
Little 6.
PW6. If she, lordship, relies on the evidence of PW6, then I have a case. Prosecution has a case, my
No, we are just making
lord.
some observations so
My
that
lord.
you can
My lord.
rebut
My
or controvert.
Lordship.
Yes.
Page 17. I lost the case. I know both the accused person. This is Renuka Hasda was my elder sister. The occurrence took place 4 years ago. The occurrence took place around 12 a.m. Since both the accused persons are my co-villagers, I know them very well. Around 12 a.m. both
Yes.
Lordship, in this matter, I think Lordship, for the affidavit, these grievances have been redressed because the final gradation list was placed in the higher position in the private respondent.
My lord,
Okay.
what happened, my lord? He challenged the provisional gradation list. And meanwhile, during pendency, my lord, final gradation
Okay.
list was published.
Heard
He's given.
Mr. B.P. Bora, learned counsel for the petitioner, and Mr. G.K. G. Boisho,
My lord.
learned standing counsel. Guwahati High Court for the respondent number
2 and
2 and 3. Also heard Mr. Any state counsel? No. Full stop. The petitioner.
Private respondent.
Also heard Mr. N. Burman, learned counsel for the respondent number
6.
6. Full stop. both the petitioner and the respondent number 4 at the relevant point of time, comma, were serving in the establishment of the respondent number.
CGM Kokrajhar, my lord.
So you are also 4 also, 2, 3, 4.
My lord.
In the establishment of the respondent number 4, that is, comma, the chief judicial magistrate, comma, Kokrajhar, at Kokrajhar. As full stop, as lower division assistants. Full stop. The appointments of the petitioner and the respondent number 4 to the post of LDA were made pursuant to a select list dated 10/10/2013, right?
My lord.
Full stop. In the said select list, comma, the name of the petitioner figured at serial number 58, whereas the name of the respondent number 6 figured at serial number 105. Right? Full stop. The petitioner belongs to what category? OBC. OBC category.
My
And the respondent number 6 belongs to scheduled tribe within bracket plains category. Full stop. The contention of the petitioner is to the effect that as per a notification dated 10/10/2023, comma, the appointments should be made in order of merit. Full stop. Because of certain inadvertent mistake, comma, the name of the petitioner was reflected in the select list. The name of the petitioner in the online application was mentioned as Santosh J. Paragraph 3 just. KBK Jadhav instead of Santosh KBK Jadhav, right? And as a full stop, pursuant to the publication was select list, comma, the petitioner had joined in the post of LDA on 21/3/2014, right?
He joined on 24th, my lord. And private.
On
My
24/3/2014.
lord.
Whereas the respondent number 6 joined in the same post on
21/3/24. 2014.
full stop. Full stop. It has been stated that the appointment orders in favor of the petitioner and the respondent number 6 were issued on 15/3/2014 with the condition that one had to join within a period of 15 days
15 days.
therefrom,
My lord.
right? Full stop. Comma. According to the petitioner, comma, the cause of action arose to prefer the writ petition when in the provisional gradation list, comma, the seniority, the name of the petitioner figured below the respondent number 6.
6.
Full stop. It has been contended in the writ petition that as the petitioner had joined within a period of 15 days from the order of appointment dated 15/3/2014, comma, his position in the gradation list ought to have been at a higher position than the respondent number 6. Full stop. Para. The in the affidavit in opposition filed by the respondent number 2, 3, and 4, comma, it has been stated that which paragraph?
Para 9, 8 and 9.
The challenge that had been made by the petitioner in this writ petition was in respect of a draft gradation list dated 27/12/2018, comma, which was not finalized at the time of filing the writ petition. Full stop. The respondents have contended that the petitioner had preferred the writ petition without waiting for the publication of the final gradation list. Full stop. It has been stated that after consideration of all the objections as regards the draft gradation list, comma, the final gradation list was published on 21/4/2020. Full stop. In the said final gradation list, comma, the petitioner has been placed as serial number 11, and the respondent number 6 has been placed at serial number 13, comma, meaning thereby, comma, the petitioner has been placed at position higher than the respondent number 6. Full stop. It has thus been contended that the grievance of the petitioner raised in this writ petition has already been remedied with the publication of the final gradation list on 21/4/2020. And as such, comma, the petitioner has no cause of action to continue with the writ petition. Mr. Bora, learned counsel for the petition, has agreed to the stand taken by the respondent number 2, 3, and 4 as regards inter se positions of the petitioner vis-a-vis the respondent number 6 in the final gradation list dated 21/4/2020, and has fairly submitted that the writ petition can be closed. Full stop. Mr. Bormon, anything?
No.
Mr. Mormon, Planet Council appearing for the respondent number 6 has submitted that has admitted regarding the publication of the final gradation list dated 21/4/2020. Full stop. In view of the submissions made by the Learned Council for the parties in the aforestated manner, comma, this court is of the considered view that there is no cause of action surviving in the present writ petition, and accordingly, comma, the writ petition stands closed.
Item number 2.
Remove Paul Nut.
May it please your lordship.
Hmm.
Lordship, actually, I am on behalf of SCGHC. I would pray for an adjournment today
Hmm.
because SCGHC ma'am is on a
Who is SCGC?
Sumitra
Sharma.
S. Sharma ma'am. She is actually on a very unavoidable personal commitment.
Okay,
And lordship, actually, I took the consent of the other side,
okay.
but I just missed mentioning because I had to go outside.
Okay, your name?
P. Devi. On
P.
behalf
Devi, Learned, MS P. Devi, Learned Council. Appearing for MS S. Sharma, Learned Standing Council GHC for the respondent number 2 and 4 has submitted that MS Sharma has some personal difficulty to appear to conduct the case today. has sought for an adjournment, full stop. It is submitted by MS Devi that consent has been taken from the learned counsel for the other sides to make the prayer, full stop. As sought for, release the case after 2 weeks.
Lordship,
Whenever.
short date may be fixed.
Hmm?
Short date if Lordship. is in
Then, yeah. Short date, 2 weeks, huh?
2 weeks.
Hmm. Let it be 2 weeks. On a date to be fixed by the office, post of the learned counsel for the respondents shall file their respective counter affidavits on or before the next date of listing.
Obliged.
Item 3.
Service.
Yes, why it has come?
Lordship, service has been complete, perhaps Lordship. Because
Okay.
Lordship, there is a private.
Are Mr. S. Borua, learned counsel for the petitioner, and NK Sharma,
NK Lordship,
MK or NK,
NK
and Nogao,
Lordship.
NK Sharma, learned counsel representing Mr. HK Das, learned standing counsel GHC for the respondent number
2, 3 and 4 Lordship.
2, 3,
and
and 4. Full stop. As per order dated 21/4/2024 of the Lawajima Court, the service of notice upon the respondent number 5 is complete. Full stop. As the service of notice upon all the respondents is complete, office to list the case in the admission column after 2 weeks on a date to be fixed by the. On a date.
Item 4. Item 4 with 5.
We have to write now, hardly 3 minutes. What is this? Review? Ah. You have not appealed?
No. Because what is your Lordship, the Priyanka International case was based on the building bylaws of 1998.
Have you quoted new bylaws?
Yes, Lordship.
Where is it? Now, first tell me, again, it is an interlocutory basically order. It is not a final order. Now, whether a review is maintainable, first on the point of law, it is not a final opinion. I have given a tentative opinion. But by that, your interim prayer is rejected, declined. So, if interim prayer is allowed, writ appeal is maintainable. If the interim prayer is not allowed, writ appeal is maintainable. Now, in such situations, the review is maintainable. Show me the law. Whether review is maintainable. Then we'll come to bylaws. Now, what there might be some pleading that the review is maintainable. Hmm?
Regarding maintainability, there is no direct rating.
Where is the building bylaw?
1998 bylaw.
Let us see.
19 bylaw. That clause 7 was not there.
You are marked.
Yes, it's just for the text.
I get a book. 1990.
98.
1998.
Yes, Lordship, that was relied upon in deciding the Priyanka International.
Which one?
This 1998 bylaw was relied upon because the building permission was of because of 2000. Oh, sorry, because of 1998.
Priyanka was of 2010.
2010, that has so there the issue was relating to the building bylaws that was of 1998. Here is compoundable portion when it is within the FIR limit, this can be compounded. That was not there. That has come subsequently.
Which year? Which year?
In 2014 bylaw.
14 খন আছে আমার হাতে। Building bylaw.
Yeah.
You want to say this is 2014 bylaws?
No, that is 1990 bylaw act. So that is not available.
Mr. Come to page 22 then. You want to say that in Priyanka International Supreme Court had extracted the building bylaws wrongly?
No. That I-
Come to page 22 then.
It is not expected. I think their case was.
I have extracted only the from Priyanka International, this part, page 22.
Lordship, that bylaw is not applicable in that case because in the present case, that because the subsequently building bylaw was amended and 2000, I was granted permission as per the provisions of the 2014.
If this is
bylaw.
correct,
2014.
huh? If this is correct,
Lordship, that is.
this one is correct or not? Correct.
It
Then-
is, 2023
Let us see the edition.
appendix 3.
This is 2021 edition. 2021 edition.
Lordship, the difference is between the 1998 bylaws and 2014 bylaws was there.
This is 2014.
In appendix 3 of the.
No, this is appendix 3.
In 1998.
Tell me the difference. Now compare with this appendix and the appendix at page 20, reflected in page 22. Please. Of your review,
I will not find it.
second file. If it is available. Or the main repetition. Order dated 7/2/2024.
Page 22.
Make a comparison between this appendix and that appendix. Yes.
So my lord,
Is there any difference between the two appendix?
yes,
Which one?
if you look at and see, 7 clause number 7 is not there.
Which one?
In the-
See that appendix. See that appendix. See that appendix and compare with this order.
Yes. Yes.
After non-compoundable item, what is item number 2? Non-compound. Non-compoundable.
No, that is in,
In the book also,
yes,
what is item number 2?
okay. Non-compoundable. Before that matter.
Before that, this was taken into account by the Supreme Court.
No, Supreme Court taken into account my lord 2019.
No,
19 rule.
no, mister, if I may be wrong, but this has been extracted, this order, appendix 3, that paragraph 6 of the order. First 5 lines, inter alia observed as under, right? In the order passed by me. Paragraph 5. Then the next portion is in a different font. Different font. And this font is extracted from Priyanka. Priyanka. There, appendix 3. Please see. Appendix 3. Thereafter, penalties to be levied, right? Then compoundable items. Your contention is at par, item 2. Then below, non-compoundable items, item 2, addition of extra floor, right? And that has been interpreted by the Supreme Court. This is next page, paragraph 50 was quoted. Paragraph 50 was from the Supreme Court. It is not necessary to deal with the aforesaid judgments of this court in greater details as a consistent ratio decidency of this code is that if the constructions are in absolute violation of sanction or approved plans and are not likely to fall in the category of compoundable items, then the necessary consequence is to order its demolition and seal of approval for such illegal activities is not required to be given by this court. This is the interpretation of Appendix 3, where this FAR is also available, and this addition of extra floor is also available.
Compoundable table also, your lordship kindly see, that is not a missing man. Compoundable table, madam, your lordship kindly see.
That I am not in a position to interpret now.
No, that by 2014 rule, that compoundable portion 7, subclause 7 was introduced. That is not there, madam.
Which one? See, it is there.
No, my lord, that is not.
Book.
Book, my lord. It is 2014 rule, my lord. Your lordship kindly see in compoundable portion, kindly see.
Also see non-compoundable portion.
No, my lord.
That is what?
While my lord deciding the Priyanka's case, my lord, that was not there.
It was there.
No, it was. In
Then please bring, I have quoted it from, because to my knowledge, I have quoted it directly from
No, while my lord I am submitting, my lord, 2000.
rule of
because
Priyanka.
Priyanka's case, my lord, permission.
2010 to SSC 27. Whatever, this appendix was directly quoted, extracted from Priyanka only. I did not exercise.
Yes, I agree. Priyanka, only, but Priyanka, my lord, that is quoted from my lord 2019 rule, my lord.
But the interpretation is
1999 rule.
compoundable item. Please see in the order. Compoundable items. 2, FAR. Right?
My lord,
Compoundable items 1, 2, 3, 4, 5.
my lord.
Next. Compoundable, non-compoundable items.
Don't come on, lord. Additional extra flow.
Addition of extra floor.
My
Now read the paragraph 41, which I have already extracted.
Yes.
Appendix 3 of building bylaws deals with penalties to be levied for violation of provisions of master plan, zoning plan, regulation, and bylaws. Certain items are compoundable items, but certain items fall in the category of non-compoundable items. However, addition of extra floor falls in the category of non-compoundable items. Thus, in any case, anything that has been constructed beyond 5th floor would be non-compoundable and same cannot be compounded at all. In other words, minor deviations from the sanctioned plane should be confined only to FAR permissible, but should not extend to extra floor.
That's why I'm submitting, my lord. That in Priyanka's case was as per my lord, your lordship kindly. While I go for the non-compoundable.
Show me what under what bylaws you are trying to get into the non-compoundable item. That is what, please tell me.
Additional extra floor to be accommodated area within the compoundable effort. So that's 7 was not, my lord, in the 2019-99 rules, my lord.
7 is there, lordship, but
Now 7 is there,
but see the condition, subject to compoundable FAR.
my lord.
Compoundable
Sir,
FAR
that
is 10%, lordship.
Counseling commission, my lord, they send it back to the authority, my lord.
No, one more.
Suppose one has a four floor.
That is what I'm interpreting. lordship.
1 minute, miss, I am posing a query. You have already permission was 4. You did it 5th. You did a 5th. No, there is another story. 1 minute. It cannot be compound and compound and compound. It cannot be a story of compound and compound and compound. It does not make, because if suppose one floor is, suppose just as a hypothesis, one floor is given 25%, then 4 floor is 100%. You have added 1 floor and got it compounded already.
That is 10% per.
That means 125. Let us assume it is 10%. Now, then we have to hear and make more orders.
Yes. Thereafter, it is not possible. That far area
That is not
compoundable
possible.
Up to 10%.
You
That
will hear it, is still not possible today. Because this interpretation seems,
same law. In the earlier rule also, that same provision was there, but this 7 was not there, but the same interpretation
that
was there.
note is added, note is added.
But what your lordship will follow in this matter, in my humble understanding, lordship, the principle laid down in Priyanka state case, lordship.
No, no, what is there? Addition
Take
of extra,
construction.
that is not compoundable.
Lordship.
Note is that additional floor will mean additional floors beyond the compoundable affair.
Yes.
Yes.
Now, what did you compound already?
4th floor has already been compounded.
My lord.
Regularized.
No, my lord, so far it is, your lordship can be.
Okay, I will hear matter, but question is that against an interim order,
No, my
either
lord,
declining or allowing, a retable is maintainable.
no, that's true, my lord.
Even court grants. And it is not you are not a private respondent, that it was passed ex parte. Whatever I have heard, rightly or wrongly, I have passed an order.
Believe, my lord. Why I am submitting, otherwise I am not filing any new petition, my lord. Why I am submitting, my lord, then.
Since Mr. Nayak has got the copy, whether you filed a thing that whether compoundable can go on compounding.
Look, even if this interpretation is taken, lordship, even if as submitted by my
Please
colleague,
read petition file. I am posing a query. I am posing a query to Mr. Mohanto as a layman, not an expert in building bylaws. I think you have projected in the writ petition, if I am correct. Huh. Page 23 of the writ petition. And place your, how much area was the 4th floor?
Yes.
Now I'll go on. I will examine 4th floors. Whether it is 10% or 25%. Because every floor is about how much? As per page 22? 192.48
lordship.
square meter. Meaning thereby, it will be how much? 10% of R?
10%.
Then please get the calculation right. Mr. Monto, 10% of, because by page 23, it has been compounded already. Read, this is certified G plus 4th floor situated at so and so. Cover was regularized by way of receiving penalty amounting to rupees so and so. The 4th floor of the building was regularized by compounding as per appendix 3 of building bylaws. Now, if your interpretation is to be accepted, then you complete 4th floor, compound, then again 5th floor, compound.
That I understand, my lord. I am telling because probably, my lord, that clause 7 was not been placed before what lordship.
Okay, we'll see. But page,
Otherwise, I understand, my lord. So
page
tomorrow-
23,
Tomorrow, my lord, I allow you, your lordship allow me 6 floor, then I go for
Yeah.
2nd floor. Yes, I understand.
it will be Empire State Building.
That is not my punishment.
No, what was the main contention of the petition was that, my lord, layering council order, my lord, without complying that they have demolished them. They have demolished already.
Now tell me whether your case on the basis of page 23, whether appendix 3, can you invoke? Because you have already compounded.
Yes, one floor.
Yes. Now tell me by the area also.
My-
For 10%. Tell me by that area that more thing is compoundable because you G plus 3 only.
Yes, original permission.
That is, that you have compounded the fourth floor.
Then hopefully they have no more. Yes. That is the intent.
Beyond that, it is not going into my mind.
My main intention is to really file a review petition that probably that clause 7 was, subclause 7 was missing. That's why it was not been.
Because I was aware of this pages. I have gone through.
Cases might not earlier.
I have gone through, and that is why I have taken exception to this member of the appellate authority. Because the way he has done,
My lord.
the language he has used, but I said this far and not far, the appellant will definitely
Here-
prefer.
Yes, given the.
I'm expressing my mind that I thought that whether let it be tested, my order be tested. Actually, but today it is out of time, Mr. Nayak, you find out
I will tell.
compounded, then compounded and compounded. If this goes on,
Now, my lord, problem.
if the GMC or GMDA goes on compounding floor after floor, is it possible?
No, no.
Now, my lord, because of after 4 floors, I am unable to contact. You know, everything seen. Everything, my lord, even 4 floor, I cannot do it.
That is has to be challenged. We are only,
There is no separate order. Because of
okay, next week. Heard Mr. T.J. Mohanty, learned senior counsel, assisted by Mr. S.N. Tamuli, learned answer for the review petition. But how it is regarding note, this note,
regarding, yes.
is it your pleaded case?
No, regarding review. Probably because I am not in main case, my lord. That order which was passed by your lordship. Because probably that was mixed out, my lord, that's why. Otherwise, I could have done for anything, my lord. But I just, my intention is, my lord, just to place before your lord. Probably it was missed, my lord. Because Priyanka's case is well not.
Actually, it was an interim order, so I took notice of it. But since I was of the view that this court is not persuaded to pass an interim order, so I expressed so that
My lord,
avenues
yes,
are
my lord,
available for you.
Yes, because tomorrow if I had a entire matter, my lord, can you look so my lord, okay?
And Mr. P. Nayak, learned standing counsel GMC.
GMC and GD.
Close lock. Mr. Nayak, learned standing counsel GMC shall obtain instruction whether after compounding, if the fourth floor of the concerned building, any further floor can be compounded or not under the building bylaws.
That I know, my lord. Yes, my lord, that is probably not possible.
Liz,
Keep going on.
it will be Burj Khalifa one day.
Please, yeah, please,
Liz the case.
14-3.
my lord.
Lordship will, Lordship has not issued notice, Lordship.
No,
In that case, Lordship will keep
I don't feel-
maintainability of this review petition of it.
That's I don't know about the law.
That is what I'm trying to examine.
I have not come across review against an interim order. We'll find out.
My lord.
Mr. Tamul, find out law that review against interim order